Says Michael Popok, Legal AF. E Jean Carroll already obtained a judgment against Donald Trump for $5 million for sexual abuse and punitive damages and defamation back in May. But Donald Trump doesn't want to leave well enough alone. He didn't take the stand. He didn't put on any witnesses. He didn't put on any witnesses to counter her expert testimony that she put on for her psychological damages and her economic damages. And yet he has the temerity, the gall to submit papers to the judge in federal court asking for a new trial, not because the underlying facts as found by the jury are not true, but because he thinks they awarded her too much money. And then he cites a series of cases having nothing to do with E Jean Carroll or the facts of this particular case to say that the jury wrote too big of a check on his bank account. Well, boo-hoo. And shame on you for trying to penalize and victimize E Jean Carroll once again. Just to keep all the matters straight, because there's so many things going on with E Jean Carroll and Donald Trump in the courthouse, let's separate it. In May, a 9-person jury, 6 men, 3 women, returned a verdict in favor of E Jean Carroll, finding that she was sexually abused, sexually assaulted under New York's penal criminal code. She was there in a civil case based on the allegations because they heard testimony. And this is going to be a little bit graphic, but I'm going to use what happened in the trial. They heard testimony and believed her, and the weight of the evidence, the preponderance of the evidence, that Donald Trump inserted at least his finger into E Jean Carroll's vagina during a sexual attack in a dressing room of a department store in Manhattan in spring of 1996. The only reason the jury didn't return a verdict of rape is because New York is a kind of one of the only states, there are a few others, that doesn't find rape if there's no penis involved. If there's no penis involved and it's other parts of the body, like fingers, in New York, that's sexual assault. It's still a crime, and still terrible to have happened to you, which it did to E Jean Carroll, so says the jury. Other states would find that to be a rape. And that's the only technical reason that Donald Trump says, well, I wasn't a rapist, I was a sexual abuser, as if that covers him in glory and that vindicates him. And we'll talk about how the lawyers for E Jean Carroll took on Donald Trump in their filing. But so that's the first case. The second case you probably heard a lot about, just got filed several weeks ago, is off of the CNN town hall a couple of days after the jury verdict that I just described against Donald Trump. He defamed E Jean Carroll again and said that she was a hoax, a charlatan, he never knew her, never met her. Exactly the opposite of what a jury, after listening to dozens of witnesses, 80 pieces of evidence, looking at photographs, hearing 2 experts testify, none from Donald Trump, no witnesses for Donald Trump, what they ultimately concluded. Jury has spoken, and they've rendered a judgment and a verdict, and that is that Donald Trump is a sex abuser because of what he did with his fingers and her private parts in that dressing room. Period. End of story. And the continued denial of it and calling her a fraudster and a hoaxer and all of that is not just victimizing her again, it is defamation. And now they're seeking a $10 million punitive damage claim, a punishment set of damages against Donald Trump, because he won't stop. And so the law has to provide some remedy for the unique injuries that E Jean Carroll is suffering on national and international television at the hands of a madman who's completely out of control. And that would be punitive damages. That's what the court has at its disposal. That's the second case. But now back to the first case, Donald Trump doesn't like the $5 million number. And that was broken down as follows, just for those that are keeping track. $2.7 million was awarded to her for defamation damages because the jury believed, obviously, the expert testimony of her defamation expert who said, as against the tens of millions of social media impressions, tweets and other things that Donald Trump did against her, that she would need at least $2.7 million to operate a counter campaign to rehabilitate her reputation. And that was the estimated cost for her going out and hiring PR firms, media firms, reputational repair firms to help her. And that is the exact number that the jury awarded, $2.7 million, obviously crediting completely the expert testimony of her damages expert. And they didn't have a counter expert because Donald Trump's counter expert got sick the day he was supposed to testify. And I'm not making this up, and the lawyers like Joe Tacopina said, we don't have an expert. All right, that's how that number got on the board. Then they awarded $2 million for the sexual abuse, obviously crediting the testimony of the psychologist, the psychological trauma specialist who testified on E. Jean Carroll's behalf, having examined her, who said she continues to suffer from post-traumatic stress disorder, PTSD, many layers of PTSD, that she has not been able to have a romantic relationship in over 30 years because of the trauma of the sexual abuse at the hands of Donald Trump, that she continues to have intrusive memories that stop her from progressing as a human being, that it's as if Donald Trump murdered her identity, murdered her professional reputation. She suffers from self-blame and shame, as most victims of this type of assault do. And the jury listened to all that and said, that sounds like $2 million at least of damage. And they gave another $300,000, which is sort of on the low end, for punitive damages. To me, it looks like the jury wanted to give her $5 million and then just sort of put the pieces together to get there. That verdict is going to be upheld. The judge is not going to reduce it by way of a procedure in the law that we called remittiture, where you lower the number of the jury award. The judge is allowed to do that if he finds the jury doesn't have a reasonable basis to award those amounts. And they do. They have facts and testimony, expert testimony in the trial that match up with these things. Now, the way, in a real disgusting fashion, that the lawyers, Joe Tacopina and Alina Habba, have gone after E. Jean Carroll is to say, well, she really doesn't suffer from lifetime mental illness because she said she's basically a happy person. She also testified at length about the continuing trauma to her romantic life, her inability to have sexual relations with other people for the last almost 40 years. Apparently, Joe Tacopina was coloring in his coloring book when she was testifying to that on the stand, backed by the trauma psychologist who backed her testimony. The other really disgusting, underhanded attack on E. Jean Carroll is they actually wrote in their papers, Tacopina and Habba, that, well, sexual assault can take many, many forms. And fondling over a shirt somebody's breasts could also be sexual assault. Okay, well, that may be true, Tacopina and Habba, but the testimony that came out at trial, both on direct examination led by Robbie Kaplan for E. Jean Carroll and your own cross-examination, Joe Tacopina, said that she had fingers of Donald Trump inserted into her vagina. Okay? She never talked about her breasts. She never talked about that she got felt up. Okay? That was the test. You might have got confused, Joe. That was the testimony of other witnesses, like the woman who unfortunately got upgraded to first class and sat next to Donald Trump and got groped by him on the plane, including on her breasts. But E. Jean Carroll, the plaintiff in the case, Joe, she testified even in response to your own question, which, of course, the brief that was just filed by E. Jean Carroll's lawyer mentioned, that would you believe that during the trial, Joe Tacopina, during his cross-examination, actually spent time in front of the jury with E. Jean Carroll and asked her to explain whether Donald Trump was just, I'm using his words now, this is quotes, rummaging around her vagina or inserting his fingers into her vagina. Let me just let that land on this hot take. That was the defense strategy that Donald Trump's lawyers used, as if that made a difference to either E. Jean Carroll pinned up against the wall in the dressing room or to the jury. And the fact that he kept ringing that bell in front of the jury is mind-blowing as a trial lawyer. So the jury, listening to all the facts that were presented, came up with the right conclusion. The judge is not, I predict, with supreme confidence, going to lower the amount that the jury awarded at all. Some people might be asking, can he raise the amount? It's unusual. In a remitter, you can lower, and nobody's asking him to raise it, so I doubt he will raise it. But let me read for you just one paragraph out of 34 pages, just powerful stuff by E Jean Carroll's lawyers, Robbie Kaplan at Kaplan the Kaplan Hecker firm. Okay, and you'll see where I'm going with this. Ready? Here we go. This is in the preliminary statement on page 8. Importantly, on this motion, Trump does not seek to disturb the jury's verdict on the merits, meaning he's not disturbing the facts that the jury concluded. Rather, he takes issue with the amount of money that the jury awarded Carroll as damages. But Trump's motion is nothing more than his latest effort to obfuscate the import of the jury's verdict by engaging in his own particular Trump-branded form of magical thinking. Isn't this so eloquently put for everything that we've been thinking? Back to the brief. Once again, Trump has the nerve to claim public vindication from the jury in this case when, in fact, the jury determined that he penetrated Carroll's vagina with his fingers without her consent and then defamed her. His factual misrepresentations about what happened at trial are only compounded by the legal errors in his brief, both in articulating how courts have applied the relevant standards to assess battery and defamation jury awards, and in suggesting how those standards should apply to the damages awarded here. As explained below, the court should reject Trump's request for a new trial or damages, or for the court to decrease on its own the amount that the jury determined that Trump now owes. Let's all remember this. I'm going to use it in hot takes and on Legal AF. I love this phrase. His own particular Trump-branded form of magical thinking, where he believes he's been vindicated because he was only found to have committed the crime of sexual abuse in the way that I just described it, and not rape. Bravo. Bravo, Trump. You're a sexual abuser criminal. So found a jury in New York, not a rapist. And that's what he stands in front of rallies, his cult followers, MAGA followers, who are like the three monkeys of famous Chinese mythology. Hear no evil, see no evil, speak no evil. They don't hear or see anything wrong with Donald Trump because they have buried their head in the sand and they won't listen to the facts. Not facts that are presented and developed by a trier of fact like a federal judge in the Jan 6 hearings or Jan 6 trials, by courts of appeal, by the Supreme Court, by federal judges and state judges all around the country, by facts that have been developed by juries and special grand juries. All of it is a lie in their perverse world, right? That's made up of magical thinking and some sort of weird apocalyptic candy land. That's what they're left with because the facts don't matter to them. And remember, you may be entitled to your own set of opinions. Everybody is. But you're not entitled to your own set of facts. Okay? And that's why the Republicans and the MAGA had to make up this concept of fake news, which really they mean fake facts, because they don't like the real facts as developed by juries in New York in favor of E Jean Carroll. He lost the case. She won the case for $5 million. She's going to win the case for punitive damages for what he did to her at CNN's town hall. If he does it again, she's going to win again. And this judge is not going to lower the jury verdict. That's my hot take. I bring it to you only on the MeidasTouch network about every day. I sit at that intersection of law and politics because I'm qualified to do it, because I've been a 32-year trial lawyer in courts just like the ones I talk about. And I talk to you about these politically charged litigation matters. And then on Wednesdays and Saturdays, we pull it all together in a specially curated podcast, long format called Legal AF, which I co-anchored and co-founded. We do it on Wednesdays. We do it on Saturdays. If you like what this is all about and you want to kind of signal that to me and to the network, give me a thumbs up. You can leave a comment. I've been known to talk back. We can open a dialogue. You can follow me Michael Popok on all things social media at MS Popok. This is Michael Popok, Legal AF reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.